What is mootness, and why does a federal court dismiss a case on the grounds that the case is moot? Today, I'm going to break down this concept of mootness, and I'm going to discuss a case called DeFunis versus Odegaard that perfectly illustrates the concept of mootness in federal courts. So mootness does not appear anywhere in the U.S. Constitution, but our courts have held that it's part of Article III, just like standing and ripeness, which also do not appear in the Constitution. Article III, of course, relates to the federal court's power to hear cases and controversies. So when is a case actually moot? A case is moot when it would have no effect on the rights of the parties that are litigating it, or that some event outside of the litigation has brought the case outside of the reach of federal law. So the case of DeFunis versus Odegaard is a 1974 case decided by our Supreme Court. It was written per curiam, meaning that no individual justice authored the majority opinion, or at least signed their name on it. So in 1971, the petitioner, Mr. DeFunis, applied to law school at the University of Washington in Washington State. He received a rejection letter. He ended up challenging in 1971 the admissions policies of the university, and he alleged that the admissions policies basically invidiously discriminated against him on the basis of race. So he was essentially challenging the affirmative action. Now, he did not file this as a class action. He just filed it in his own capacity. So he wasn't bringing in extra plaintiffs who felt they'd been adversely affected by the policies to challenge the admissions policies. He was just taking it on himself. So he's the sole party here. He ended up winning in the trial court. He got the injunction that he wanted against the admissions policies, and he got admitted to University of Washington. So by the time his second year of law school rolled around, the case made its way to the Washington Supreme Court. And the Washington Supreme Court reversed the trial court. They reversed the injunction that the university had to seize its policies. Then DeFunis, obviously upset by this loss in the Washington Supreme Court, filed a writ of certiorari to have his case heard by the U.S. Supreme Court. And this is where the issue of mootness starts to come up, because now it's 1974, and at the time that the U.S. Supreme Court is deciding DeFunis' case, DeFunis is already a third-year law student, and he's in his second semester of his third year of law school. So basically, there's 6 semesters of law school, and he's in the middle of his 6th semester. He's about to be done. So the U.S. Supreme Court ends up holding that this case is moot. They articulate that federal courts have no power to decide questions that cannot affect the rights of litigants in the case before them. They cite the case of North Carolina versus Rice. They point out that all parties now agree that DeFunis is going to be entitled to finish law school. This isn't a class action case, so nobody's rights are on the line except for DeFunis's, and he only wanted an injunction as his remedy. He didn't seek damages. He's now irrevocably admitted to the law school, to his final year of law school, and it's pretty much certain in the eyes of the majority, the per curiam opinion, that he's going to finish law school. So no matter what the Supreme Court reaches as a decision, neither DeFunis nor the University of Washington are going to be impacted by that decision. So they point out, too, that there are a number of cases saying the voluntary cessation of allegedly illegal activity doesn't deprive the court of the power to hear the case. So that's, it's sort of an exception to mootness. So the idea would be, the policy reason for that is just because the defendant has stopped doing these allegedly bad guy things doesn't mean that the case is moot, because we still have an interest in stopping the defendant from engaging in these bad acts. But this doesn't apply here, basically, because the issue here with the mootness is not that the university has voluntarily ceased its admission policies. It's that DeFunis is going to graduate law school. There's nothing that's going to stop him in the eyes of the majority. It's settled. And although the exception is there, it does not apply. They also point out another exception that doesn't apply for a case that's, quote, capable of retention yet evading review. And they say this is not one of those cases because DeFunis is never again going to be required to deal with the school's admissions processes again. If there's another attack on the policies, then that litigation will likely bring itself up to the Supreme Court. They have no doubt that the admissions policies, if they are unconstitutional, can be challenged and brought to them, and then the U.S. Supreme Court can handle them in that case. But this case is not an appropriate case for them to handle them. Then, of course, there's a dissent by Justice Brennan. Justice Brennan takes a different view. He says the case is not moot, obviously, so he disagrees with the disposition. He also disagrees with the majority, saying that this is a case where voluntary cessation needs to be stopped, or this is not a case where it needs to be stopped. He says some unexpected events might prevent DeFunis from finishing law school, so we need to keep those in mind. There might be something that ends up getting him out of law school in his final semester, and then he might need to go through the admissions process again. And in that case, the admissions policies would be valid and used against him. So he thinks, yeah, this guy actually is going to be subject to the admissions policies again. So yeah, he's kind of taking into account a lot of different scenarios that might play out, however unlikely, and saying, look, it's in the public interest for us to hear this case. We absolutely should not just dismiss it as moot. So yeah, those are the two different perspectives on DeFunis, the majority and then the Brennan dissent. This perfectly illustrates the idea that when the court views the case as not having any impact on the rights of the litigants, it's moot. The court is not going to hear it. So let me know what you think about mootness down in the comments below. I look forward to hearing your opinion. If you found this useful for understanding the concept of mootness, please like, comment, and subscribe. I would really appreciate it. We're trying to grow this channel. We're trying to increase our reach. We're trying to further educate people on the law. So yeah, if you're a law student, I really hope you found this video helpful too, because I know this can be a really difficult subject. Federal jurisdiction is really wacky. But yeah, that's all for me. I will talk to you in the next video. Thank you.